Welcome to Hong Kong. I apologise that I can't address you in French today, but my French is as good as my Chinese, I'm afraid. So even though I haven't been studying French for about 35 years now, the number of years that I've been in Hong Kong is also a testimony to my ability not to speak Chinese as well. Okay, so today I'm going to talk about the visas that are applicable in a situation where you're thinking of starting a business here or you're going to take up employment here. It may be that you want to start a business here or you have a business here and you want to recruit foreign nationals to come and work in your Hong Kong business. So this presentation is going to speak to those situations and also to the situations which impact on family members that will be forming part of any visa situation as regards Hong Kong. Okay, so let me start by saying that we're going to talk effectively about Hong Kong immigration and how the structure of the policy is configured. And I'm going to explain to you that over the course of the 20 years that I've been doing Hong Kong immigration, things have very much remained the same, although they have changed in some critical areas, especially as a result of the handback of Hong Kong to China in 1997. You're going to hear me discuss how the Immigration Department go about considering applications for immigration status for foreign national residents or intending foreign national residents. And you'll understand and learn that actually the Hong Kong system is not very legalistic and is not very bureaucratic. As with all things in Hong Kong, you'll find that the Immigration Department are very pragmatic and very entrepreneurial focused. They're looking to try to approve applications if at all possible, rather than refusing those applications. Because Hong Kong has a very free and easy visa upon arrival regime, most first world nationals that arrive here are granted a very liberal amount of time when they arrive at the airport, usually between 90 days and in the case of British nationals, 180 days. And what this means is that usually foreigners arrive here, they're admitted at the airport with almost no questions asked as a visitor. And they look around and they can see that there's fantastic opportunities. And then they run off and they start businesses and they start talking about opportunities in Hong Kong. And all of this is good and it's fine and it's encouraged, except for the fact that the immigration permissions that are being used as a visitor are not actually suitable for these types of activities. So I'm going to explain to you what is permitted activity if you come as a visitor and what is not permitted activity, and how the Immigration Department distinguish the two types of activities and ensure that when you make an application for the right kind of immigration status, subsequently, you can expect that the Immigration Department will indeed approve those applications. We will look at the 4 particular types of immigration status that is available to enable people to live and work in Hong Kong. And we're going to talk about the arrangements, as I mentioned, for accompanying family members, both for the traditional family members and increasingly the non-traditional family members. Not every application that the Immigration Department receives gets approved, and there are some very discrete reasons why cases do get denied. So I'm going to explain to you exactly why cases do get denied and what you can think about in order to ensure that when the applications are being anticipated, that the correct type of structure is in place so that the case will get approved rather than refused. And then for the vast majority of foreign nationals who come and convert their status from visitor into some kind of residence visa, they, after 2 or 3 years, start to fall in love with Hong Kong. And as a result of that, there's always one eye on the long term and how can you adjust your status from an interim temporary visa, which is what everybody gets for the first 7 years of their residence here, into permanent residency. So I'll talk you through the criteria for approval for the purposes of permanent residency subsequently. So the thing that characterizes Hong Kong immigration that's very different from every other immigration immigration jurisdiction, is that there is no predefined set of rules and regulations, or laws in fact, that the Immigration Department publish on a regular basis. Effectively, the ability for the Director of Immigration to manage immigration policy is devolved to him through the main law, which is called the Immigration Ordinance, and that policy that emerges from the legislation is derived into the hands of the Director of Immigration, who makes the rules up as he goes along. What this means is that over time, the body of know-how and information that goes to allow people to understand how the Immigration Department are thinking about implementing that policy, in a sense, is developed, and it changes with the economic circumstances of the age. So when I first started doing this 20 years ago, when I was looking for the law straight out of law school to try and understand exactly how I should be advising my clients on getting immigration status here, I couldn't find anything in the law library. It simply didn't exist. So 20 years ago, this is what I was doing. I was wandering around in the dark, about to fall off a cliff. And now, 20 years on, because I have enough experience to know how the Immigration Department work and operate, and what's essential for approval, and where the pitfalls lie in an application that could expect to be denied rather than approved, effectively moving chess pieces around with the Immigration Department in order to educate them to the requisite degree so they can understand whether or not a particular application should be approved based on the merits of the circumstances. So the whole area of Hong Kong immigration is very opaque. So, having said that, what are the policy criteria that the Immigration Department apply, in a sense, from 39,000 feet? Well, firstly, it's based on flexible conceptual hurdles that you're expected to overcome in your application, rather than as it is in many other jurisdictions, such as the United States or Australia or Canada, where there are fixed and hard and fast laws that you are working to in determining the approvability situation for any particular application. So the policy is not legalistic, and it isn't overly bureaucratic. The intention of the Immigration Department is to try to approve an application if it is at all possible. And they are looking to facilitate commercial, bona fide, and other social advantageous activity. So it's a double-edged sword in many ways. You tell the Immigration Department what you're trying to achieve, and if they like what they hear, they will grant you the visa if it's at all possible. By the same token, if you tell them something that is going to compromise your ability to get the visa approved, they will refuse your application. And because there is no government gazette or any other published information that the Immigration Department make available as to what is needed to get a case approved. In many ways, you're groping around in the dark. But there are three undercurrents to the way that policy is administered here. And these are: the Immigration Department are looking to protect local jobs wherever possible. They are seeking to promote the investment into Hong Kong that foreign nationals and foreign businesses can deliver. And because the Immigration Department are part of the government's Security Bureau, there is always the issue of security. So there's an element to every single application where the Immigration Department are going to do an assessment on an individual, and if they believe that there is a security objection to this person being granted a visa, or indeed a particular business coming into Hong Kong, if they think that there's a problem associated with allowing that business to come to Hong Kong, they will refuse the application on security grounds. So the final thing to understand is that since 1997, when prior to that date, British citizens had all the advantages associated with living and working in Hong Kong. These days, the focus is not so much on any specific nationality as it was before 1997, but they are looking to try to facilitate the best of the best from China to come into Hong Kong. But because there's 1.2 billion Chinese people that would like to come and live and work in Hong Kong, they have put up a certain barrier that stops effectively the large hordes of the many numbers coming. They're looking for the brightest and the best and the richest. And as you'll see when I get to the relevant point in the presentation, you need to be a particularly high quality candidate for immigration permissions if you're coming from the mainland. And why this is important is if you are thinking about establishing some kind of business presence in Hong Kong and you expect to have mainland employees come and work for your office in Hong Kong subsequently, you need to be aware that there are certain conditions that apply specifically to mainlanders. So the focus is on attracting the best mainland talent, not large numbers. So that's how policy is presently configured. Okay, so as I mentioned in my short introduction, the vast majority of people that come to Hong Kong arrive as a visitor, and they're granted 90 days, 180 days, sometimes just 30 days, depending on your nationality, when you arrive at the border. And so the question is, what is permitted activity if you come as a visitor? Well, I've listed here the kind of activities that is authorized under Hong Kong immigration policy right now. So if you're coming for a genuine business visit, so you're going to come, you're going to have your meetings, you're going to interact with the parties in Hong Kong, and then you're going to leave, come back sometime in the future. But that type of activity is naturally enough permitted activity under the visitor visa category. On the other hand, if you're going to establish some kind of business here, or you're going to be relocated here in order to take up a future employment, it's perfectly okay to arrive as a visitor. It's perfectly okay to prepare all the on-the-ground activity prior to commencement of formal business activity or prior to taking up formal employment duties. That's perfectly acceptable. Where it becomes unacceptable is where you engage in that business or where you start to take up those employment duties. So pre-relocation for business residence orientation, but no assumption of the job-related duties, is how the Immigration Department provide the activities that are permitted under the visitor visa category for those types of people that are in the process of making those types of rules. If you're coming to participate in a trade fair, that's perfectly lawful under the visitor visa category. If you're going to speak at a conference, that's perfectly lawful. Indeed, if you're going to have a small stall or a small shop at the trade fair, and you're going to be selling things within the parameters of the trade fair, that is permitted activity as a visitor. But like everything with Hong Kong immigration, it's important to realise that it's the attitude of the immigration department to prosecuting you for breach of conditions of stay if they discover that you're doing something that may not be commensurate with your visitor visa status. And in the final analysis, you find that typically if the immigration department discover that people have been engaging in activities which are not strictly in accordance with your conditions of stay as a visitor, they will merely slap you on the wrist and send you away, and that tends to be the end of the problem. The immigration department don't have the resources to go around prosecuting everybody for minor breaches of conditions of stay as a visitor. But it's very different if you have come to Hong Kong with a clear intention to join in a business or to work for somebody else, and then you start that business, or you start working for somebody else as a visitor, then you are vulnerable for prosecution for breach of conditions of stay. So it's a very flexible scheme of arrangements when you arrive at the airport, and the immigration department are not going to discourage entrepreneurial activity. But as we'll see a little bit later in the presentation, the immigration department expect you to submit your application for the residence visa the moment your intention to reside has crystallized. There are a number of different visa categories that are up for discussion today that relate to working and doing business in Hong Kong. And the first is the employment visa, which is based on a third party offering a job to a foreign national. And in those circumstances, the immigration department apply an approvability test to that situation. And what they do is they ask, does the applicant possess special skills, knowledge, or experience of value to and not readily available in Hong Kong? And moreover, the sponsor, that's the local party seeking to employ that foreign national, must be justified in engaging the services of the foreign national staff rather than those of a local person instead. So there is a tension at play in the employment visa based on a job offer. Now, in the main, if you are operating a business in France and you have some kind of business presence in Hong Kong, or you're thinking of establishing some kind of business presence in Hong Kong, and you need to relocate talent from France to Hong Kong to promote your business endeavors in Hong Kong, in that intercompany transferee situation, 99 times out of 100, the immigration department will say yes. The expectation of the personal qualities of the individual applicant are those that you would typically expect. You'd expect them to have a good education. If they haven't got a formal university education, that doesn't preclude the visa from being approved, because if you can show that the candidate has at least 5 years senior managerial responsibility working for either your company or a similar company, then the fact of that prior employment experience in a senior managerial capacity will do away with the need for a formal tertiary education, for example. The immigration department do not expect that every company that wants to employ a foreign national has to go and physically look for that talent in the Hong Kong workforce. So there is no need to be artificially advertising for the position. either if it's an intercompany transferee, or indeed if you have a foreign national candidate who's manifestly qualified, manifestly experienced to do that particular job, you will find the Immigration Department do not encourage you, the Immigration Department will not force you to look for that talent locally. And the rule typically is the greater the salary, the greater the title, the greater the responsibility inherent in the role, the less problem you're going to have with the Immigration Department in satisfying them that they do possess special skills, knowledge and experience of value to and not readily available in Hong Kong, and also that that talent cannot be found from within the local workforce. There are about 17,000 employment visas issued each year in Hong Kong to foreign nationals, and about 25,000 that are issued to mainland Chinese that come to Hong Kong under a similar program. So if you're a mainland Chinese and you want to take up employment here, you use a program called the Admission of Mainland Talents and Professionals. And this is a program that is designed to keep out all those mainland Chinese other than those that are exceptionally well experienced and exceptionally well qualified. And a similar set of approval criteria apply to foreign nationals that are going to be taking up employment with a third-party employer. So this is the employment visa based on a job offer with an independent third-party employer. So the next type of visa that we need to talk about is the business investment visa. And again, this particular visa type is managed under the general employment policy, which is the same policy that applies to the first type that I've just explained to you, the employment visa based on a job offer. The business investment visa is an interesting animal because the Immigration Department don't have any fixed idea or notion of what is present in the structure to get this type of visa approved. The approvability test for the business investment visa is different from the third-party job offer employment visa in as much as this visa looks to the business operation. The business operation needs to be able to show it can make a substantial contribution to the economy of Hong Kong. Now that's different from the employment visa based on the job offer, because there the focus is on the individual candidate who needs to show that they have special skills, knowledge and experience of value to and not readily available in Hong Kong. So if you are in France and you want to establish a business operation in Hong Kong and you're doing this for the first time, you've got two challenges you need to overcome. The first challenge is if you're bringing somebody from France, you need to be able to show that that person has got special skills, knowledge and experience. But if you have a completely new business situation in Hong Kong, you also need to be able to satisfy the Immigration Department that your business can make a substantial contribution to the economy of Hong Kong, because this business is going to serve as the formal sponsor for those employment visa permissions. And when you're establishing a new business situation, the approvability test is looking for certain kinds of things to expect approval. When you're establishing a new business situation, the approvability test is looking for certain kinds of things to expect approval. Firstly, they expect that at some stage in the future, your new business operation is going to generate local employment opportunities. Now, there's no requirement to create those local employment opportunities straight away, But in the argument that you make to the immigration department for any application in a new business situation, you're going to have to show that in due course, just through the normal course of business, local employment opportunities are going to be created. The second thing that the immigration department are looking for under this visa type is that you've got the right kind of home for your business. And in this regard, they're looking for suitable business premises. Now, what is suitable depends entirely on the nature of your business. If, for example, you are a typical trading concern, then the immigration department would expect that you'd have offices that accommodate places for people to do trading type activity, and also some kind of showroom or some other facility that would effectively support a trading type business. So that would be suitable business premises. On the other hand, if you are an internet focused business and the majority of your work is going to be done either outside of your own particular business premises on client sites, or your employees are going to be located in other places doing what they do, you could have, for example, a mere virtual office or a simple serviced office, and that would be suitable for the purposes of acceptable business premises under this visa class. Finally, the immigration department are going to look for the types of resources they would expect to see in a new business situation, so that they can be satisfied that eventually the business, whilst new today, will go on to become a solidly entrenched commercial enterprise. So they want to see what kind of resources you have. In this respect, typically acceptable resources are your profile in France. What have you been doing there previously? What business connections have you got here? What's your rationale for establishing in Hong Kong at this time? How much money are you bringing to Hong Kong? What do your finances look like in France, and what do the projections look like for Hong Kong in the future? So the immigration department are looking for these kind of resources to satisfy themselves that in actual fact your business does stand the chance of making a substantial contribution to the economy of Hong Kong. The immigration department will also expect to see that as a resource the business has got funds available to it. Either funds that are sitting in your bank account in France that can be transferred into Hong Kong whenever they are needed, or funds that have been transferred to Hong Kong to finance your early business activities. Usually about 6 months' worth of cash flow will suffice to satisfy the immigration department in this regard. So how much cash investment is like asking how long is a piece of string. But it's one key resource that the immigration department are expecting to see, because they don't want to approve a visa application sponsored by a new business, a new company that is going to close its doors after a few months because it doesn't have the necessary level of finance available to it to sustain itself during the early part of its establishment endeavours here. Okay, so I mentioned earlier about permitted activity as a visitor, and then the opportunity to come to Hong Kong as a visitor to establish a new business, or to pre-relocate to engage in activities prior to relocating here. And what is the situation in relation to any kind of activities that you've engaged in as a visitor in anticipation of establishing the business and making an application for a residence visa subsequently. And there's a problem, there's a tension in the way that Hong Kong immigration policy is administered in relation to the business investment visa. Because if it's a new company situation, the immigration department expect to see that you have got all the necessary pieces in place to allow the approvability test to be satisfied, and the way that the application process is administered, the Immigration Department, in a sense, tacitly encourage you to engage in activities in Hong Kong that are not commensurate with your conditions of stay as a visitor. Because the test is that you need to show benefit to Hong Kong, but you can't join in a business until you secure the consent of the Immigration Department. And you can't secure the consent of the Immigration Department until you can show benefit to the Immigration Department. And you can't show benefit without joining in the business, and you can't join in the business until you've got the consent of the Immigration Department. So this is this tension. And the way the Immigration Department solve this problem is very pragmatic. What they say is this: if you're here as a visitor and you're engaging in activities which are squarely within the realm of a business investment visa, if you don't have an application in the system, you're vulnerable to prosecution for breach of conditions of stay. But if you have an application in the system, they close their eyes to any transgressions. So the lesson here is that if you've decided that Hong Kong is where you're going to be doing business, and you have a need for any person associated with that business to have an immigration permission to do it, then you need to make your application as soon as you can. And once the application is in, you're effectively protected from any negative consequences as a result of engaging in activities which are not commensurate with your conditions of stay. On the other hand, you could make your application for a business investment visa even before you arrive as a visitor, showing to the Immigration Department everything that you intend to do, purely on the basis of a plan, and that's fine. In those situations, though, the Immigration Department will expect to see you capitalize your Hong Kong company at a much higher level than if you had just come as a visitor and began to put in place everything that you need to start your processes for the visa application whilst you're here as a visitor. Does that make sense? Yeah? Okay, great. Okay, so we've looked at the employment visa and we've looked at the business investment visa. There's another visa category that will allow you to come and do business here and also work here, which is called the Capital Investment Entrance Scheme. And this was a program that was introduced 10 years ago, 2003, where if you have 10 million Hong Kong dollars and you invest those 10 million Hong Kong dollars into certain kinds of Hong Kong qualifying investment asset classes, then after about 6 months, you can expect that the Immigration Department will give you a free and clear visa to be able to come and live and work and engage in any kind of legal activity in Hong Kong with no further questions asked. This visa class was developed in response to similar visa types that have been available in other jurisdictions for quite a long period of time. However, there have been question marks as to whether or not the real spirit and the economic intention of this visa class actually serves the purpose for which it was designed. Because one of our economic commentators here in the South China Morning Post, our English language newspaper, very respected guy called Jake Van der Kamp, made the point quite eloquently that whilst we can secure visas for people if they put 10 million Hong Kong dollars into certain types of assets, the way that the balance of payment system operates, in reality, Hong Kong is not actually benefiting in the way that the government feels that they are. So that's just a minor point, but it does illustrate that the Immigration Department, in a sense, are pragmatic. If they can encourage rich people to come here, Hong Kong's going to benefit. Indirectly, if not, according to strict economic criteria, in the way that this commentator has suggested. So 10 million Hong Kong dollars takes about 6 months to get this visa approved, and you need to have shown that you've owned the assets that are being invested into certain assets in Hong Kong, the money, the funds that are being invested into the assets, you need to show that you've owned them for 2 years immediately before you submit the application for this capital investment entrance scheme visa. Okay, so 3 major classes of visas that allow people to come and live and work in Hong Kong. What about family members? Well, Hong Kong is a very interesting place, again, very pragmatic in the implementation of immigration policy. Because actually, in order to get a dependent visa for your family members, you need to show that you are legally married and that your children who are joining you are under the age of 18 or in full-time employment, full-time education. And if you can meet those conditions, then the principal employment or business investment visa holder needs to be able to show that he can put, or she can put, a roof over the head of his family members and food on the table of the family members. And that in the case of especially a new marriage where there are no children, that the relationship is a genuine relationship. It's not such a problem. But the real beauty of getting a dependent visa is that with that permission, you as the dependent visa holder are free to do any kind of activity in Hong Kong whatsoever. So you can join in a business, you can start a business, you can work for somebody else, you can study, you can paint pictures of the harbour, whatever it is that you wish to do. So once you get the dependent visa, your ability to engage with society is unrestricted as long as it's legal. Which is ironic, because if you're going to get an employment visa or a business investment visa, the immigration department make you jump through all these hoops to be able to secure that status. But once you get a dependent visa, you're home free. You don't have any of those things to be concerned about. So this could be interesting in the situation if you have a husband and wife business team situation and you want to come to Hong Kong. You get one of them an investment visa and you get the other a dependent visa. You stay silent as to the intentions of the spouse that's getting the dependent visa for joining in the business, because the approvability test for the dependent visa is to show dependency, roof overhead, food on table. But you stay silent as to the intention behind the spouse who's going to be getting the dependent visa, and after approval, he or she can immediately join the business and do all the things that they plan to do as a business team anyway. Okay, so that deals with dependent visas. What about if you're a non-traditional family? If you are a de facto spouse, where you're life partners, but you have decided for your own reasons that you're not going to marry? Well, strictly speaking, to get a dependent visa, you need to be legally married. But if you're a de facto spouse, if you have a de facto spouse relationship, what the immigration department do is, rather than break up the family, they will give to the trailing partner a prolonged visitor visa, which is exactly the same visa as you get at the airport. But instead of having to keep coming and going in and out of Hong Kong every 3 months to extend your visitor visa, you go to the immigration department in advance. You submit an application that looks very much like a dependent visa application. And you show that the principal partner in Hong Kong that has the employment or the business investment visa can put a roof over the head of the partner and food on the table of the partner. You can show that, and as long as there has been a prior cohabitation prior to coming to Hong Kong, then the immigration department will give a prolonged visitor visa to the trailing partner. The problem with the prolonged visitor visa is it really is just what I call a slippers and pipe visa, because the partner can do nothing more than wait at home for the husband to come back at the end of each day and hand him his slippers and his pipe. That's all that they can do. So whilst it's a pragmatic solution to keeping a family unit together, it isn't a very satisfactory immigration status which the de facto spouse actually is able to secure. There is one condition precedent to a prolonged visitor visa for a de facto spouse situation, and that is both parties must be free to marry but choose not to. So it can get very complicated if, for example, in the case of, say, Filipinos, where they don't have a divorce law, where relationships from 10, 15, 20 years ago could have broken down, and the parties have moved on and they're doing different things with their own lives now, and they find themselves in Hong Kong and they can't get a dependent visa because they're not legally married, and they can't get a prolonged visitor visa because they are not free to marry. So there is a wrinkle to the prolonged visitor visa. So that's the situation in relation to unmarried partners. But also, what about if you're a gay partner? What happens in that situation? Well, same-sex partners are treated in exactly the same way as heterosexual de facto partners. You need to be able to show that you're in a lifelong, committed, loving relationship, that you've been living together before you came to Hong Kong, and that one partner is going to sponsor the other partner. And this is a policy that the Immigration Department don't advertise, and they are very flexible, and they're open and amenable to the granting of prolonged visitor visas to same-sex partners. But unfortunately, even if you're married as a same-sex partner, or you have a civil union as a same-sex partner, you still can't get a dependent visa, because dependent visas are restricted to heterosexual, legally married partners only. So now I'm going to explain why cases get refused. Business investment visas. The Immigration Department don't put out exact statistics on how many applications are approved or refused. But looking at the Immigration Department's referencing system each year, you can see that there are between 3,500 and 5,000 applications for business investment visas submitted each year. But the Immigration Department do put statistics out on the number of approvals, and there are between 350 and 500 approvals each year. So the overwhelming majority of business investment visas that get submitted to the Immigration Department don't get approved. Now that would suggest that somehow it's very, very difficult to get an investment visa approved. Actually, what this is a symptom of is the way that the Immigration Department construct their policy. Because what they do is they have a website that says, if you are planning to establish or join in a business, give us these documents, we'll consider your application, and then we'll let you know. What they don't do is provide the kind of information that you need to have a real understanding of your chances of approval. So it encourages people to make applications that really should never be in the first place. But in real terms, each year there are approximately only 10 to 15% of the total number of applications submitted that go on to get approved. And as I say, that's mainly because you have a lot of candidates for this visa class who shouldn't be submitting applications because they never stand a chance of getting approved in the first place. There are 17,000, as I mentioned, employment visas issued each year, and they're probably double that number that are submitted to the Immigration Department, again looking at the file referencing sequence. So it's my experience that approximately 50% of applications that the Immigration Department receive are refused and 50% get approved. So why do these applications actually get denied? Well, they get denied because they should never have been submitted in the first place. The, the pillars of approval that I mentioned, sources, suitable business premises, and the creation of local employment opportunities in a new business situation. These may not have been articulated to the Immigration Department, so the Immigration Department don't have the information that they need to make an informed decision about whether or not this visa application should be approved. Secondly, there could be something in a particular applicant's background that it worries the Immigration Department. They could have had a negative prior record. They could have been refused entry previously. There could be some major security issue that we're not privy to. But there are security considerations, and cases get denied for that reason. Some cases are never going to get approved because of the circumstances. So, for example, if you're a Chinese citizen resident on the mainland, if you're going to come into Hong Kong to get an employment visa, you need to use the Admission of Mainland Talents and Professionals scheme. However, there is another small policy that says if you have been living outside of China for a minimum of 12 months and you have residency in another country, then you can make an application just like any other foreign national. It's a small rule, but some people submit applications where they don't meet the criteria for the admission of mainland talents and professionals, and they haven't spent the 12 months outside of Hong Kong, outside of China, immediately prior to submitting their application here anyway. So that's another reason why people can be refused. Cases get refused because the way the Immigration Department website is set up, there is no easy and straightforward advice or guidance on how to construct your application. So if an applicant has prepared its papers in a very poor way and hasn't told the Immigration Department what they need to hear, then you can expect that to get approved. Excuse me, to get refused. Similarly, if the Immigration Department have asked for information and the candidate hasn't been able to supply it, and you see this quite often in the context of financial reports from overseas. Maybe that there's a certain sensitivity in releasing your financial data, your audited financial statements, to the Hong Kong immigration authorities. If they ask to see that and you expect them to grant the visa, you have to give them that information. And it isn't sufficient to say, well, it's confidential, we prefer not to. In those situations, you can expect the Immigration Department will say no to the application because they haven't been able to determine for themselves everything that they need to be able to apply the approvability tests to those types of applications. So, where the Immigration Department asks for information, you need to give it to them. And these are the main reasons why applications do get denied. We conclude now that the Immigration Department have granted the right visa to the right person in the right circumstances, and they get their visa. Initially, you get a 1-year period of stay. At the end of the first year, you make an application for an extension. If there have been no change in the circumstances in that time, you'll then get almost automatically, even though you must apply still, you get a 2-year period of stay. And at the end of those 2 years, you go through the extension exercise again, and you get another 2 years, assuming there's been no change in your circumstances. At the end of those 2 years, you make an application for the final extension, and they give you 3 years. That's a total of 8 years. What that means is that by the time you get to 7 years, continuous ordinary residence in Hong Kong, you can make an application to remove all your conditions of your immigration status. And you can do this on the basis that you want to become a permanent resident. And once you become a permanent resident, effectively, you become a Hong Kong citizen almost. You don't get a passport, but the rights and the privileges that go with permanent residency are the equivalency of citizenship. So the test for permanent residency after 7 years is, have you been continuously and ordinarily resident in Hong Kong for a period of not less than 7 years, and any absences from Hong Kong in that time, have they been of a merely temporary nature, as evidenced by what you leave behind to return back to each time you make a trip away from Hong Kong. So permanent residency is available to you in those circumstances. And the Immigration Department don't put out any numbers on permanent residents that are granted, foreign nationals who are granted permanent residency on this basis. But there's an interesting issue associated with permanent residency in Hong Kong, because there are two types of permanent residency. There's the permanent residency you get if you're Chinese, and the permanent residency you get if you're not Chinese. It's all based on Chinese nationality law, and it's quite complex and it's quite convoluted. But the two differences are as follows. If you're Chinese and you get permanent residency, you cannot lose your permanent residency. You get the right of abode forever. If you're a foreign national and you have permanent residency, you can lose your right of abode after 3 years if you don't come to Hong Kong on at least one occasion in those 3 years. So the Immigration Department will allow you to keep your right of abode all throughout the time that you are physically present in Hong Kong on at least one occasion in any 3-year given period. If for any reason you can't meet that condition and you're away from Hong Kong for more than 1,095 days, I think it's 1,095 days at a stretch, you are downgraded from the right of abode to the right to land, which is slightly different in terms of you can't vote, you can be deported, and you're not going to be able to benefit from the various government incentives that are available to permanent residents of Hong Kong, such as the taxation advantage, stamp duty advantages associated with buying property here now. There's one other downside, and that is your future children will not get the right of abode if they are born in Hong Kong, if you only have the right to land. So there are some considerations. And I was present at a talk that the first Chief Executive, Tung Chee Hwa, gave just after the handover, when the final policy for permanent residency and the right of abode for long-stay foreign nationals was announced. And he explained that they had thought long and hard about how to address this dichotomy between PR for Chinese nationals and PR for long-stay foreign nationals. And they felt that the 1 day in 3-year rule was really very, very liberal and was certainly sufficient to allow people to maintain their right of abode and enjoy the same quality of experience that Chinese people get as well. So it was quite a pragmatic solution to that particular problem. So for many employment visa holders and business investment visa holders and their families, permanent residency is the end game, and so it's worthwhile having a discussion about that today.